Use in commerce, this is one of the big keys to being able to obtain a trademark in the US is that you must use it in commerce. You must use it, your trademark that you're filing for must be on the goods as they're being sold or used in commerce. And similarly for services, you need to use your trademark, your slogan, your logo in connection with marketing or providing those services, and you have to provide those services in commerce in order to meet that requirement. But here's a question that's, really about a fine point on that does come up a decent amount, so I wanted to make a video for everyone to see. This is from a potential client that I spoke with the other day. I, of course, copy and pasted it or snipped it so that you can't see their details for privacy concerns. But let's say I wanted to file my mark after I was using my trademark in commerce in order to be eligible. Would my goods have to be sold in multiple states, or can I file once I released my goods to the public? So the answer is no, you do not have to file in multiple states, but we're going to discuss after this a case to go into a little more detail about that. Essentially, do I need to prove that I'm selling my goods nationwide or from state to state to obtain a federal trademark? And again, the question is no, you do not have to sell nationwide. You do not have to file, you do not have to sell from state to state for a federal trademark. But we're going to look at a case that gives a little more context to what that is. So also, is there a certain recommended or mandatory period for how long I would have to be using my mark in commerce before I can file, or can I just state that I'm using my mark in commerce once I've released it to the public and then have to wait a certain amount of time, i.e. 6 months or more to file? So you do not have to. First of all, you can file always an intent to use application, which means you have a good faith basis intent that you're going to use this in commerce. There are additional fees, and depending upon clients' timeframes, we may or may not file an intent to use. We might just wait until they have use. But once you have use, that day you have use, I mean, there's times we know clients are going to go live and we get the application prepared with everything except for that specimen. Then as soon as they go live, we get the specimen, depending upon what it is. We put those details in relating to that date, and then we can file it that day. So here's a case, Christian Faith Fellowship versus Adidas AG. And this case talks about use in commerce, and essentially Adidas was trying to oppose the Christian Faith Fellowship Church's application saying that they did not, or registration saying that they did not have sales at the time they said they had. The church provided receipts for selling 2 hats for, I think, a total of $38.34, and it was sold to, and here you'll see, it was sold to someone who lived from out of state. So the board held that was not enough. Now this is going to be overturned, but we'll go into that. But here's the board concluded the sale of 2 Add-A-Zero caps at a minimal cost within the state of Illinois to Mrs. Howard, who was a resident outside the state, does not affect commerce, that Congress can regulate such that transaction would constitute use in commerce for purposes of registration. The sale is de minimis under the circumstances shown here, is insufficient to show use in interstate commerce. So they're saying that's not enough. You do not affect commerce that Congress can regulate. They're saying it's de minimis. So there's, de minimis token use. That's usually when it's, if you just sell it to a friend, if you, do like or there is also sham sales where you say that you're selling it, but those generally do not account. You really need to make it available. You really need to make it available to the public and have public sales that are there. Now, the Federal Circuit, which is a federal district court that covers the trademark trial and appeal board at the U.S. Patent and Trademark Office, they said, this is enough to affect commerce. They go into it, they look at some other cases. They said commerce's powers are very broad. It does not necessarily just have to be that it goes across state lines in order for Congress to affect commerce. And one of the, they look at different cases, but they look at Wickard, a farmer grew wheat for commercial sale, but also for personal farm use. The Wickard case actually talks about growing marijuana. Ms. Wickard argued that her local and de minimis cultivation and possession of marijuana should not be subject to federal drug laws passed under the Commerce Clause. So went up to the Supreme Court. The Supreme Court said, even though you're just using it locally, it's only locally, it still affects federal commerce that Congress can regulate. And then I looked at a couple other cases. Recognizing that the Lanham Act, by its terms, and the Lanham Act is the trademark law, that's what that act covers, trademark law, by its terms extends to all commerce which Congress may regulate, and that Congress had broad powers under the Commerce Clause. We reject applicants' argument that a certain increased threshold level of interstate activity is required before registration of the mark used by a single location restaurant may be granted. So this looked at a case where there was just a single restaurant that had registered a mark, and the person seeking to cancel it said, no, they only have one location in this one state. They shouldn't be allowed to. And the court there said, no, there's enough. Just having a single location in one state is enough. There's no necessarily requirement that you have to have in multiple states. And here, when they look at it, this transaction of selling of 2 hats taken in the aggregate to a person from out of state would cause a substantial effect on interstate commerce and thus falls under Congress's Commerce Clause powers. Now, I don't know if there's an argument that whatever you're doing, you're paying federal tax in pretty much almost every state. So if you're making an income off of that, maybe there's an argument that that's affecting interstate commerce because everything is being taxed that's brought in. And then it just goes into, the statute, Lanham Act statute requires that the marks be sold or transported in commerce, while service marks must be used or displayed in the sale or advertising of the service, and the service must be rendered in commerce. But this distinction goes to meaning of use, and okay, so that goes into a little about the wording, but essentially for trademarks, the requirements for use in commerce is that you are using it in commerce that Congress can regulate, and it has to have the mark on it. For services, you need to use or display the service mark that you're looking to protect, the logo, the word mark, the slogan has to be used on sale or advertising of the services, and the services must be rendered. So this way, customers equate your service with that trademark, that brand, just like the goods need to be used, transported, sold in commerce there. So essentially what this case comes down to is that in a way, it's a very fact-based situation as to there's no bright line rule that sale of one hat to one person is going to be enough or vice versa. You need to really look at everything in the aggregate. And this case that cites it here does a good job of synopsing it, because one need not direct goods across state lines in Congress to regulate the activity under the Commerce Clause. There is likewise no such per se condition for satisfying the Lanham Act's use in commerce requirements. So there is no requirement that has to go across state lines. That's kind of the big key takeaway from this case. After that, you are going to have to look at the facts of each case. Like I said earlier, sale to a friend or just for the purpose of the trademark is generally not enough. A lot of our clients are selling online, so by that nature, they are selling across state lines. Their websites directed to people all over the country or all over the world, depending on where they are. So that's always good to look at. So any questions about this, always feel free to reach out. If you like these, please subscribe below, and thanks for watching.